Hi, good evening. So I have made a recording just to explain the breach of contract so that you can be able to understand it better. I'm going to send you the slides as well. But so this is what I did with regards to the breach of contract. So in order for us to be able to understand, the breach of contract, first of all, we need to understand what the purpose of the contract is. So I assume you already know that the purpose, a contract serves as a formal agreement that clearly spells out the terms and conditions between the involved parties in a business deal or any other transaction. So that is, it clearly sets out, the roles, the responsibilities, the duties between A and B. And also it acts as a safeguard to ensure that everyone within the parties, the contractual parties, they understand their rights and their responsibilities. And the contract also serves as a way to kind of provide remedies or to to come in in cases of disputes. And then the contract usually comes in and makes some things that are not clear to be a bit clear, because after signing the contract you would have known exactly what you're signing for. Maybe the dispute is because now there is a little bit of misunderstanding, and also the fact that maybe you forgot. It's not always clear in black and white. Maybe you forgot, so a contract would come in to set the record straight. Okay, so let's move now to the forms of breach, which you already know that there are 5 different forms of breach. You must know these by heart. The way that I would try to know these, or to memorize them, is obviously this just makes it lengthy, but you have to know that there's a default by debtor, default by creditor, positive malperformance, repudiation, and the prevention of performance. So we have 5 forms of breach. Know these 5 forms of breach: default by debtor, default by creditor, positive malperformance, repudiation, and prevention of performance. Okay, now let's dive in deeper into what the default by debtor is. So an example when talking of the default by debtor is when A and B have an agreement, and without any justification, that particular agreement, A has promised, to deliver, to meet his end of the stick, and without any justification, A delays, and it delays to perform those duties or responsibilities at that specific time. So I think, for example, if let's say you A has a farm, and he has cows, and then he's selling milk, okay, and then A has to deliver milk to you, and then that by the time that the milk is delivered, you obviously need to package it and kind of sell it or give it to your clients or whatever, right? What happens is that now A delays to bring the milk in the form of A is using suppliers, and that will deliver the milk, and A suppliers kind of delay with the milk. They stop somewhere, and then they delay with the milk for 1 day. You have lost clients, and then by the time they arrive, maybe the milk is spoiled, right? So there was no like legal justification from A. These people, they became negligent, and then they arrived late. So it is in a case where there is like delays without any legal justification, and then obviously it causes you damages in the end, right? And there is requirements. And then one of the requirements is that performance must be delayed. The delivery of the milk must be delayed. And then there is no question of late performance in the particular instance. Let's say for milk, for example, the milk got delayed or they decided to drive slowly. By the time that they arrived, the milk has already been spoiled. Okay, I hope that example will you possibly remember it during the exam. And then we have a default by creditor. So a default by creditor occurs when the creditor causes the data's performance to be delayed. And then that one is pretty clear and straightforward. The requirements is that the performance must be dischargeable and the data must tender performance. Okay, so now the creditor has delayed you and then you end up doing the work by yourself, you know. Okay, now let's move to the positive malperformance, which occurs when a data commits an action which is contrary to the terms of the contract. Okay, so now give you an example for a house, the house in which he or she has undertaken to build is built, but with the finishes inferior in quality to those specified in the contract. Okay, fine. Let's say now this person promised to build you a mansion and that this mansion is gonna have like glass doors, right? And then when this mansion is done and then it gives you a mansion with wooden doors, that's not what you had agreed on. That is positive malperformance, right? So that is one of the examples that I can give when somebody gives you something that you did not order. Okay, you order a dress because you are slim and then they bring you a dress, an oversized dress, or you order an oversized dress because you know size 35, 38, something like that, and they give you a size 28. You know, it's something that's not what you ordered. So that's positive malperformance. Or doing something that you are prohibited of doing, restraint of trade, you know, if you know what that is. A restraint of trade is when in cases of employment, for example, you work for my bakery and then I have this secret, you know, of cookies that I got from my great-great-grandparents. It's a family secret. And then I teach you that secret because I want you to be able to, you know, to bake those beautiful cookies and serve my clients. So the restraint of trade, it's a clause that comes into the contract of employment, and then it prohibits you as the employer at the time that you leave our employment relationship is terminated, that by the time that you leave, you're not going to work for any bakery for, let's say, for a period of 5 years. And then if you want to do that, you wouldn't do it like maybe 500 kilometers around where my bakery is in Johannesburg. So that's the restraint of trade. So positive malperformance is with the restraint of trade enforced, and then you still go ahead and open a bakery or you work for another bakery within the closest area. So that's positive malperformance. Okay, I hope I explained well and you understand that. Okay, so now let's go to the last one. The last one is repudiation. Repudiation is kind of clear, black and white, straightforward, where you have an agreement with A, and then you pay A to come and clean your house, and then A agrees, and then A takes your money, and then A stands right there and there in front of you, and he tells you that I am not cleaning your house. He kind of violates the contract right in front of you. And then he's like explicitly telling you that I am not doing this. So that is repudiation. So if you have any questions, oh, okay, no, we're not done. Okay, we still have a prevention of performance. I'm so sorry. We have a prevention of performance. So prevention of performance will be either by the debtor or by the creditor. Okay. So let's dive in. By the data, it occurs when one party makes it impossible for the other to fulfill their obligations as agreed upon. This can happen if the other party actively stops or hinders the completion of the agreed task, making it difficult or even impossible for the other party to carry out their part of the deal. So, okay, cool. Here's an example, nice example that I made. I said, imagine you hired a contractor to renovate your kitchen. By a certain date, you tell them you want your kitchen to be ready by tomorrow, and then you agree to purchase all the necessary materials and pay them a specific amount upon completion. And then the contractor arrives in the morning, and then he's ready to work, and then you would like, you can't go inside my kitchen. And he's like, no, but we have an agreement. You said I should come and work. And then you're like, you cannot go inside my kitchen, and I am not giving you these things that I bought, or I didn't buy these things, so you can't come inside my kitchen. So you're making it impossible for the contractor to begin with the renovations. So as a result, the contractor is prevented from performing their work as per the contract, and it leads to a prevention of performance by the debtor. Okay, so now let's go to the prevention of performance by the creditor. So this is where it's still the same scenario as with the debtor, but the other way around. So here the creditor culpable renders the debtor's performance impossible and commits a breach of contract in the form of prevention of performance. So the example that I used here is a scenario where a landlord refuses to provide repairs. Let's say your taps are leaking in the house that you rented, and then you have informed your landlord and that your landlord must come and fix these things. You pay your rent on time, you've never defaulted in any manner, and then now you have a problem. The landlord doesn't want to come and fix it, and now you are unable to fully utilize the property that you pay for in terms of the lease agreement. So that is a perfect example of the prevention of performance by the creditor. And then this is the end. Thank you very much and enjoy the rest of the week. Good luck with the exam.